There are many different things that are going to happen during a Social Security disability hearing, and I wanted just to take a minute today to go over what some of those items are. So one thing that the judge will cover with you is your past work history, and they typically look at the last 15 years. There might be medical experts present at your case who give a summary of the medical file and then give an opinion about what such an individual would be limited to when it comes to work. When the medical expert is done testifying, it would then be up to you or your attorney, if you have one, to cross-examine them. So ask that medical expert questions that would ultimately be helpful to your case. The judge will also ask you a bunch of questions about your health impairments and how they affect you on a day-to-day basis. And they will want to go over with you your activities of daily living and what your personal limitations and abilities are. Again, if you have an attorney present with you, then the attorney will be able to ask you questions as well in regards to these areas. And then at the end of the hearing, there will be a vocational expert who gives testimony about how different limitations and accommodations would affect one's ability to work. And again, that individual would need to be cross-examined as well, which would be conducted by you or your attorney if you have one. And that's where you would be asking specific questions about the limitations you have to make sure that they are properly considered by the judge and the impact that that would have on your ability to work. At this point, if you have a hearing coming up, we do strongly recommend that you have an experienced attorney with you at the hearing. Keep in mind, while these judges are often fairly nice people, it is not their job to make sure that you are putting forth every piece of evidence you need to prove your case. And at a disability hearing, it requires more than just showing that you have these medical conditions. You need to be presenting the evidence to show that your conditions fit within their rules, regulations, and framework to show that you would not be able to sustain that full-time employment. Here at Hankey Marks Crider, we can get involved in cases at any stage. So if you have a hearing coming up and have further questions, we would be happy to speak with you. Our consultations are always free, and we only get paid when we get a recovery for you.